Both our chair and Bill Malcolm are absent tonight, so I'm going to designate both Mike Wood and Dan Brand, all of us to serve as regular members of the panel tonight for all the matters that we have. We have, on the agenda, we don't have the minutes listed, but we have 3 sets of minutes to review. Minutes from May 21st, the last regular meeting, the 23rd, which was a site visit, and then the minutes of June 10th, which was our last meeting, special meeting dealing with Pinnacle. Let's take up the minutes of May 21.
Okay, I have some comments.
Yep.
A bunch of bullets in the middle of the first page, about the 8th or 9th one down. It starts, the property is located in the Ag Soil Conservation District, and the board considered granting a 200-foot building envelope. It should be called zone. And that's...
Just grab a copy of it before I...
Okay, you can use mine.
Okay.
Except there's a whole bunch of others. So you can't use mine.
Okay.
I mean, you can have mine after I read them off.
Take mine.
Okay, so page 1, the word envelope should be replaced by the word zone because that's what it's called in the ordinance. And I added then behind it, in accordance with section 327(4). Next page, under application 2015 ZB12 logic. I don't know whether we should correct the minutes or not, but what I felt was lacking is there's a discussion about the second sentence. The footprint of the combined structures will exceed the maximum building area. Combined structures will exceed the maximum building area. I assume that's footprint, not lot coverage.
I think I'm in that same direction.
Okay. I'm not sure whether it's maximum building area or footprint or what it's supposed to be, but I think if it is footprint, it should be corrected to footprint. And I didn't have the material in front of me to dig it out.
I think it might be, but I can't find my copy of the minutes where I will approve that either.
So that was part 1. And the other part that gave me a bit of a headache is, probably we can't do anything about it, is I thought on that application, we had done the calculation to identify how much was left for him. And it doesn't show up anywhere in the findings or the deliberation. So we don't have a clear record in the minutes that say he used up 750 square feet of the 1,000, whatever it is. So, like in the bullets below, it says the new structures will increase lot coverage by 42 square feet. The project proposes an increase in building footprint of 44 square feet. The project decreases building setback by 597 square feet, but there's no bookkeeping that says what the net result of those are. And it would be nice if we could get them in there, but I don't know if we can do it tonight.
So I would have to
If you could, maybe we could just defer a correction on that until the next meeting, just so it gets into the...
Or you can just ask, I can just put the correction.
Okay.
Just that in the last couple of months, the findings have been not complete. I mean, there have been a number of things that you usually say like that. You give the calculations, you give, and I don't really feel as if I should be going to David's, preamble stuff. And
No,
doing those-
no.
You should remind
Right.
us during the meeting.
You should say, hey, have you screwed up?
Yeah.
No, I hate to do that, but like the findings of 1040 and the abutters have commented and
Yeah.
that kind
Yeah,
of,
that's true.
that often we're not hearing that, and so I would love it if we would,
Yeah.
Figure out a signal that says, uh-oh.
something like
Just
this.
say something to the chairman, and maybe he'll holler at us.
Yeah.
So we do our job. There's another one, and that's the 3rd page on the Jeff Little, Jeannie McIntyre application. First paragraph, it's a question. the last sentence, the proposed location of the solar array is entirely within the agricultural soils conservation district. The proposed location of the solar array is entirely within the ag soils conservation district. I recall that that was still a question. I don't recall that that was definitive, because there's some sort of a map that says, oh yeah, a lot of the property or whole property for that area is ag soils. But one of the conclusions we drew when we did the site visit was to ask the applicant to have a soil scientist have a look at it to actually determine whether that place was ag soils, because if it isn't, then there was no reason to come to the board. So, the proposed location of the solar array is probably within the agricultural soils conservation district.
What did you submit, what did you submit to us?
I submit, based on the USDA. solar
maps- the maps that we have.
Best that we have at the
Okay,
time.
then
That
just
it-
put that in, based on USDA.
Based
soil.
on the maps, the town maps, yes. That's what we got.
And then about, two paragraphs below that, starts with Darrell Hotchkiss.
Yep.
1, 2, 3, 4, fifth line. 1, 2, 3, 4, fifth word from the right on the fifth line in that paragraph. The word if. I think that should be removed. So that it should read, if the Vidals objected to the placement, there might be any acceptable screening goals. That's all I have.
Any other revisions? So what's your pleasure as to how to deal with the missing facts? Do you want to approve them with the understanding that the zoning administrator will fill in the
Yeah.
calculation?
The calculation square
All
footage.
right, can I have a motion to approve? them?
Also move.
Yes, so moved.
Second.
Any other discussion? All in favor? Minutes of May 23rd, which is the site visit for the McIntyre property.
I have one question about it. Second paragraph under continuation of application. 1, 2, 3, fourth line down. The first word in the line is clearly. But the sentence begins, the back and underside of the array and its mounting hardware would be clearly visible from the neighboring Vidal residence. We never went over to the Vidal residence to see what might be clearly visible.
Well, that was their assertion, or that was his assertion.
That was their assertion, but that's not, yeah.
Why don't we take out clearly? The rest of the statement is accurate.
Would be visible, yes. Might,
Is that
Yes.
some, is that something?
I mean, if I can see over to their house, they can see over through. Not in the same way, not in the same
way.
perspective, but it would be visible.
And we,
I agree.
just for the record, I think we blew it there, we should go on over
Yeah,
and have a look.
we should.
But that's okay.
We should have. Yeah.
There is one question I have, is should that then say something to the effect that there is a claim made that the array is visible from.
The Vidals stated that the fact.
They stated, I
They
wouldn't say
stated,
it,
okay.
I wouldn't use the word claim.
Okay, yeah, I
Yeah.
didn't hear that. I heard it, but I dumped it. Sorry.
Any
That's all
other?
that's all I had on that
Well,
one.
could you just tell me where that is? 'Cause I'm.
Okay, on first page,
Yep.
second paragraph, 1, 2, 3, fourth line down, May 23rd. First word is clearly, I would strike that.
Okay.
Any other corrections? Motion to approve is amended? From someone?
So moved.
Second?
I'll second.
Any further discussion? All in favor?
Aye.
Approved. Minutes of June 10th, which are extensive.
Yeah, and I had some comments, but I lost them. Oh, I lost the minutes. They weren't a lot of comments.
Let's just follow what we wrote at the meeting.
It was just one, I think. Last page.
I found something.
We can get there, right? All right. Yeah.
D, the values of surrounding properties are not diminished, fine. Then the next one is D, literal enforcement of provisions and others. Could be E.
Yeah, I just thought that
Any other corrections? Move to have minutes approved? All in favor?
Yeah, I'll take care of all those.
Okay, we have three items on the agenda tonight. We have a continuation of the Pinnacle Project. And we have a continuation of the Deputy Little application and then one for Vicky Smith. We will take those in order. And on the continuation of the Pinnacle Project, we left off having dealt with the variances 1A, B, and C, and we asked two members of the board to work up drafts to present tonight on the remaining variance issues. So, I'm assuming that you made some, they've done something, or you made copies?
Absolutely. This is the one from Walt. This is the one from Alan.
you have them identified as which one?
I did not change anything in,
No, I just meant they, in the corner or on the cover sheet or something.
I'm putting a W and an A
Yeah,
on them.
right, because that's what I was trying to.
no, I don't,
Mine has my name.
Yeah.
Ah, okay. Well, that helps, but I didn't think to do that, sorry.
I don't make any changes whatsoever.
Yeah,
Just
no,
as a
I
point of.
I can appreciate that, yeah.
Which
So,
order should we take?
I think, Walter, you had the one which was based on our numbering of number 2, variance from zoning ordinance 5115C, permit lot coverage of 88,915 square feet, et cetera, et cetera. Okay, so this,
Did we go into deliberation?
we have not gone into deliberation. Let's see if there's any other commentary that's going to be, anybody's offering before we go into deliberations. Not, I assume not. We haven't had any further exhibits or anything.
No.
Motion to go into
I'll
deliberations. Second? All in favor?
Aye.
We are now in deliberations. So why don't you tell us what you've done? Well, let's take some time. Let's
You
see.
want to read it?
Yeah,
Yeah,
that'd be a
let's
good
take
idea.
some time.
Yeah.
We'll take some time. Let's start with what Walter has done with respect to the, what we have labeled previously variance number 2, with his revised description. Any comments on the revised description?
Can I make some correction?
Sure.
Okay. First paragraph.
You're on what, first page now?
First page, well, page 2 is the way
Yep,
it's labeled.
okay.
Page 2, first paragraph, under the long list of findings that are enumerated. Toward the end of the next line, it says, along, request along as,
Yeah.
take along out. That's just something that,
Where are you?
Right below number 31 in the
First
first paragraph. So you're
Line
right-
4.
Right
Oh,
there.
okay.
the word along doesn't belong there. And then on page 4, under substantial justice, see,
Yeah.
the value to the public, it should read, the value to the public in denying the variance far outweighs in perceived justice. Yeah.
Okay.
And then further down in that same paragraph, 1, 2, 3, 4, 5, 6. Line 7, third word is and, the property and. And,
Yeah.
and should be removed.
Yeah.
That's it.
I had one more.
Go ahead.
Correct.
That would be E, the second sentence. I would reorder the things. It doesn't, I think it makes it easier to read. The property is similar to other properties along the Route 10 corridor in the
rural district in topography, size, soils, wetlands. Sure.
It's just
Makes that
changing
phrase-
order.
Yeah, just a change in order, it doesn't, and I think it makes it clearer.
Oh, somebody's done the same thing as mine. Two other properties alone.
Two other properties.
You have to add the word to.
Yeah.
It says to Route 10 as our other property, so it's two.
That,
You take out Route 10 as our,
Right.
but you will then have to put it back in, I think.
well, no, it's a-
We're gonna read all
Right.
of the findings of the
Yes.
conclusions anyhow.
Right.
Yeah. So,
But-
we'll pick it up then.
Yeah,
All right.
all right.
Yeah, I agree, it's a good chance.
Anything else? Okay, let's go through. Any comments with respect to the description of the findings of facts on page 2, beyond what's already been identified?
Relating to lot coverage or findings 1, 2, 3, 6, and the whole list?
1, 2, 3, 4.
Yeah, okay.
Hearing none, we're gonna move on to the third page. Simply as a matter of style, I think at the top, we ought to simply say, considering these findings and those determined on June 10th, the board makes the following conclusions regarding the requested variance. And then
List.
go down through.
Just eliminate the rest of that sentence?
Yes,
So the board makes,
the board makes the following conclusions regarding the requested variance. At the end, I'm gonna, or somewhere, I'm gonna suggest one other thing that we ought to say. But let me just give you the concept at the moment, and that would be that while variances 2 and 3 are being considered and determined separately, they are derivative in large part from variances 1A, B, and C, which have been denied for the reasons set forth previously.
And that's something that you feel should be inserted in each one of
I think
these.
so. I think they are derivative, but let's.
I would agree.
Leave that for the moment.
Yeah.
So that could be at the, but that should be at the end.
I think so.
Yeah. I agree.
So, consistent with what we did the other night on our variance, this is the findings that Walter has written up on behalf of the board, and I'm gonna read them. There are 5 elements to the variances which must be met in order for a board of adjustment to make a favorable finding. A, the variance will not be contrary to the public interest finding. The proposed scale and density of the project on the proposed site is inconsistent with the purposes and objectives of the rural district and would significantly alter the essential character of this locality in the rural district. The lot coverage shown in the plans and requested by the applicant is nearly twice to 4 times that permitted for a single lot in the rural district, depending on whether or not the driveways shown in the plans are to be classified as public roads. Yep.
you're reading this out in deliberation to us.
I'm reading it out so that everybody can hear what we're doing.
Okay, and everybody may or may not be aware of what the requested variance was, the lot coverage. So you might want to read that.
Thank you.
First.
Thank you. This variance is what we've been previously identified as variance request number 2, separate from other issues we've ruled on June 10th. The applicant requests an area variance from the zoning ordinance section 5.15C to permit lot coverage of 58,913 square feet, in parentheses, 105,151 square feet with driveways, on the 198-acre lot where, parentheses, the applicant contends that, close parentheses, a total of 130,000 square feet of lot coverage would be permitted in a 5-lot subdivision of, or 156,000 square feet in a 6-lot size average development. So it'll be quite technical for all.
Yes. No, I like that.
Picking up on the second paragraph, under A, the property is comprised of a mixture of forested steep slopes to the east and open lands covered by wetlands and agricultural soils.
Where are you?
I'm on the
A.
second paragraph under
A, second paragraph.
Okay, sorry. Yep.
Because of the mix of agricultural soils within and the nearby the wetlands conservation districts, the practical use of the agricultural soils area is limited to the contiguous area where the buildings and drives are proposed. The area where the lot coverage relief is requested. And as a result of the arrangement of the buildings, enclosing an open area between them, any use of the remaining agricultural soils is severely constrained. Basically, the 3 to 4 acres of contiguous agricultural soils would be eliminated, permanently altering the essential character of the property. Section 3.27.4 of the zoning ordinance specifically addressed the importance of preserving agricultural soils. The primary objective of the Agricultural Soils Conservation District is to preserve and protect the town's agricultural soils by permitting only those uses which can be accommodated without destroying the usefulness of such soils for agricultural production. End of quote. The proposal for such extensive lot coverage in the limited area of agricultural soils on the property clearly violates what is considered to be the public interest as expressed in the description and objectives of the Agricultural Soils District. The zoning ordinance as currently enacted represents the public interest in what is permitted or not, and under what circumstances or restrictions. Granting the variance will be contrary to the public interest because it would violate basic zoning objectives. For the foregoing reasons, the variance requesting relief from the lot coverage limitation in section 5.15C is found to be contrary to the public interest. The other day, the way we proceeded was to vote on each of these separate findings as we went. Is there any comments or changes to this finding? May I hear a motion?
I move that we
Make the finding.
make the finding and deny that this, deny that it, and state that it will be contrary to the public interest. That's I think where I should say.
A second. Any further discussion? All in favor of the motion as worded?
Aye.
5-0, support. Finding B, the spirit of the ordinance is observed finding. The proposed development and requested lot coverage covers a substantial portion of agricultural soils in the Wetlands Conservation District. These districts, quote, are established in order to protect Lyme's natural heritage and agricultural soils and to ensure that the land is developed only according to its natural capability, close quote, section 3.27. The proposed development is located in the rural district, among whose objectives is, quote, to protect the existing pattern of rural land uses in town, close quote. Further, quote, less intensive land uses are permitted in the rural district to ensure that uses complement each other and are consistent with the existing character of the district, close quote. The limitation on lot coverage set forth in section 515C is consistent with these definitions and objectives. The requested relief from the lot coverage criterion set in 515C is clearly in contrast with these objectives. As noted above, the requested coverage as shown in the plans would eliminate the agricultural use of the only viable contiguous area of agricultural soils on the lot in violation of the objectives of section 3.27. Furthermore, the Conservation Commission and others have noted that the project would have significant impact upon wetlands and other rural features. The intent of the limitation on lot coverage is to assure that properties are not developed for uses beyond those that are specifically permitted in the districts defined in the zoning ordinance and do not significantly impact those features that the conservation districts are designed to protect. For the foregoing reasons, granting the variance requesting relief from the lot coverage limitation in section 515C is found to be contrary to the spirit and intent of the ordinance. I have a motion with respect to that. Fine. Any comments or changes? Yes.
It's very minor, 4 lines down from the beginning.
it should not have a buffer.
That's in the ordinance.
Oh, Walter.
I just cut and paste. I didn't have to think on that one, so
Nonetheless, we can be correct.
we can be correct.
Okay.
We could write the word sick after it, right? Doesn't that do it?
That would do it, yes, because you are.
But I'd put a
quoting the
K on
ordinance.
that if you were gonna do it.
No.
Yeah, let's put sick in.
Any other corrections? Any motion with respect to this finding?
I move to accept the finding and to deny the variance.
That's good.
I had a motion. I move to accept the finding that the variance requesting relief is contrary to the spirit and intent of the ordinance, and therefore the variance should be denied.
Any further discussion? All in favor of the motion as worded?
Aye.
5-0 is the vote. The third finding, substantial justice is done. I hope I got all that changes correctly. The value to the public in denying the variance far outweighs any perceived justice to the applicant. The requested relief from lot coverage standards would seriously impact the agricultural soils and wetlands on the property, damaging areas that are specifically set aside in the ordinance for preservation and protection. The damage would be irreparable, replacing sensitive areas with buildings and roads. But not by denying the variance, the existing features of this property are preserved and remain consistent with the objectives of the zoning ordinance and other properties in the rural district. The property may still be developed within the existing constraints of the ordinance, satisfying the objectives of the rural district and the conservation districts on the property, thus resulting in a significant gain to the general public. For the foregoing reasons, granting the variance requesting relief from the lot coverage limitation in section 515C does not result in substantial justice to the applicant. Any other changes?
There was a change you didn't read, sorry.
Yeah,
That we picked up earlier.
The
You said-
value to the public in denying the requested variance.
The requested
Denying the
variance.
requested
Requested
variance.
variance, okay.
Far outweigh.
Thank you.
That was that.
Thank you. Any other changes? A motion for approving this finding?
I'll move.
Second.
And then the finding is that the granting the variance would not result in substantial justice. Any further discussion? All in favor?
Aye.
D, the simplest of all. The values of surrounding properties are not diminished. Fine. There is insufficient definitive testimony to support a determination that granting the variance will diminish surrounding property values. Any changes?
I'll move that.
Yeah,
I
this-
second it.
yeah, okay. And this is not a finding of one way or another. It's simply
Yes.
saying insufficient evidence.
Right.
All in favor?
I disagree.
You disagree, go ahead.
It is a finding that there is insufficient evidence.
Right.
Yeah,
Right.
So we could not demonstrate whether there's
yeah.
an
Sorry, but
increase or decrease
if I didn't say that,
in property
okay.
values.
Thank you.
And I think the one that we did the week before has me as moving something that I don't think is what I meant.
You were supposed to say that in terms of the minutes.
I know, and I forgot.
Oh, okay.
So you would like it to be the same as this, which was
Yeah,
a statement?
more or less.
Yeah.
Yeah, just the fact that the motion that I intended to give at that time was that there was insufficient evidence, and therefore the board could not find
Like the
that there was either an increase or decrease in property values.
We don't say that from last week.
I know.
That's what he's trying to change.
Yeah.
Somebody else worded the finding, and then somehow I got roped into moving it, and I didn't, at the time I moved it, I didn't even quite understand the wording properly, and I wanted to change it, but I
So it's an easy change. The way it reads now, before, last week's, the board concludes that there is insufficient evidence. We can say the board finds that there is insufficient evidence.
That's fine too. It was the wording of the actual motion though that showed up in the minutes
Right,
that reads inconsistent, that statement. And I didn't catch it when I was reading through this stuff. And I think it should be corrected.
it should be consistent, which is what you're bringing up, because it's based on the past one.
Okay. The easy one.
Yeah.
So the minutes do say the board voted unanimously on a motion by Walter, seconded by Ralph, to approve the finding that there is insufficient evidence.
That's correct. To conclude that the value of surrounding properties will not be diminished by granting variance. Well, then why was I so twisted around about it? It's okay.
Oh, good.
Good enough. Sorry.
Okay, all right.
Do you want to repeat that exact same motion? There's consistency in doing that, because it's what we said on our first variance.
I don't think we need to.
Okay, fine.
I don't think we
I
need
All right.
No.
to. All right, number E, last one. Little enforcement of the provisions of the ordinance would result in an unnecessary hardship finding. There is no unnecessary hardship to the applicant. The property is similar to other properties along the Route 10 corridor in the rural district in topography, size, soils, wetlands, slopes, forested lands, and proximity to Route 10. Several such properties are also close to water bodies, including Post Pond. The ordinance specifically addresses properties of this type and limitations on the dimensional requirements that must be adhered to. Such provisions are intended specifically to recognize and preserve those features that characterize the rural district. The applicant has shown that the reasonable use of the property can be made in accordance with the provisions of the ordinance through a subdivision process that might result in 5 lots of single-family residences without a need for the excessive lot coverage relief being sought. For the foregoing reason, relief from the lot coverage limitation in section 515C does not result in unnecessary hardship to the applicant, and the variance should be denied. Any other changes? You motion to go out of deliberations?
I so move.
Second? All in favor?
Aye.
I just have a little concern with this finding and Alan's in respect to the variance criteria in RSA 674-33. The RSA says there are 2 sets of criteria. If one fails, then you have to evaluate on the second set. And to me, it's not clear that both sets of criteria are being shown in the decision. And so it's just my concern that both those sets of criteria would need to.
The A and the B paragraphs.
Right.
Okay.
And
So
all of the
I
findings, or just?
I assume that what you were looking for then is something in A that would talk about that there is a fair and
There's no-
substantial relationship existing between the provisions of the ordinance
Yeah.
and then these limitations.
And that the proposed use is a reasonable one. That those are the 2 criteria for A. I mean, do you want to read I have the
But
RSA right here.
I think what he's suggesting is something similar to what we did there.
Anyway, that's all I have.
Is the proposed use a reasonable one?
No, you have to make there are 2 findings in A, and both have to be affirmatively made. If you make a finding that there's a fair and substantial relationship between the ordinance and the limitations, then that takes care of A. And then in B, you have to find that in order to be a hardship, there have to be some special circumstances peculiar to this unit that are not true for others. And so what I think David is suggesting is he wants a finding that there is in fact a fair and substantial relationship between the provisions of the ordinance and the limitation in section 515C. I think that's what you said. Or do you have other language?
I don't have any other language. I guess my concern is that, the way that the RSA is written, you look at A, if A fails, then you have to consider B. And
What if A doesn't fail?
then that
You
finding would
can,
be.
you can still consider B. There's nothing that prevents that, right?
In other words, can you do it both ways?
Can you do both?
Yeah.
Can you address both subjects? I think we talked about this last meeting.
I thought.
Yeah, that's
I thought,
right.
yeah.
It would be useful to have some other language.
You brought it up, actually.
Yeah, I mean, I think something similar to what we did last time works.
Oh, that's fine if we can suggest the right words.
I'm just concerned that if down the road someone's looking at this, they're looking at seeing that only one section, one set of criteria was established.
Can you read it out loud?
I'm reading from the variance worksheet, where it extracts the language of the statute. And so what, the first finding that you need to make, if you're talking about unnecessary hardship, is whether or not there's a fair and substantial relationship between the general public purpose of the ordinance provision in question and the application to this property. And like we said in the prior time, there is a fair and substantial relationship between the purposes, according to what you've said, of the ordinance provision 515C and its application to this project,
Correct.
which would then satisfy condition A.
Okay, and what's condition B?
Condition B is if you hadn't satisfied A, then an unnecessary hardship would be deemed to exist if and only if, according to owing to special conditions of the property that distinguish it from other properties in the area, the property cannot be reasonably used. in accordance with
Special
the
and
ordinance.
special and unique.
Right.
But
We
have we
said-
not addressed that, I thought?
We did in the earlier one, we didn't,
I
but
thought we
what
did.
David's raising here is a question of whether we,
Well, let me ask another question.
Yeah.
So if you don't satisfy A in your finding, it is sufficient to satisfy B.
Not according to what, that's your concern, right, David?
No.
No, my concern is that just that, to be sure that if A is not or that both of those conditions are, it seems like
you'd like to nail the coffin twice with making sure that there's a finding under A and a finding under B.
yes, I think that's the
I
best way.
think that's what I'm saying.
And that's what we did
With that, like,
in reverse. I mean, we
Yes.
did B
Yes.
first and A second.
yeah.
And I don't have any problem with doing it. Certainly, I think it's, the facts support both conditions having been.
Yeah.
We've stated both.
But I just didn't get the words in properly. And if you got good suggestions on how to change them, I struggled with it. And let me suggest something.
Yeah, I mean, I think you could use the same sentence.
I do.
The other two.
Let me suggest something.
Maybe we should,
Yeah, we have to go
Maybe
together.
another good, yeah.
Also
sorry.
move.
Second?
All in favor?
Aye.
Go back in deliberations, yeah.
Okay, so in the June 10 minutes, the first sentence of that particular finding criteria is, the board finds the lot is neither unique nor distinguishable from other similar properties in the rural district.
And that's B.
That's.
That's part of B.
Yeah, but
Yeah.
that's exactly what it
Yep.
reads.
Yep.
Okay, so
You're saying add that?
I propose to make that the first sentence
Okay,
of my finding.
okay,
Remove "there's no unnecessary hardship for the applicant."
Yeah.
We can say that later
Yeah.
okay.
and insert sentence one.
The board finds that the lot is neither unique nor distinguishable from other similar properties in the road district.
Right.
Okay,
And the next sentence is a copy or is the same set of words or the same set of information as my second sentence, although slightly different word. Okay, similar to topography, soils,
Yep.
wetlands, soil, forest, several such properties also enclose water bodies, which I wanted to include,
yep,
including those properties specifically addresses. The ordinance has delineated such properties. The ordinance specifically addresses properties of this type as part and limitations of dimensions that must be adhered to. And that's where I deviated from the wording of earlier.
yeah, I mean, all I would really suggest is that we think about the fifth sentence in the earlier one.
Earlier.
Since the owner may pursue other, albeit less intrusive residential development under current terms of the ordinance, a fair and substantial relationship does exist between the general purposes, public purposes of the ordinance and their application is
Okay,
fine.
and the particular wording that I used to express that idea, but didn't follow through with the conclusion of the sentences, that has shown reasonable use of the property can be made in
Yep.
accordance with the provisions of the ordinance through subdivision process, might result in lots of 5, 6 residents, et cetera, et cetera. And what we could add after that sentence is,
Thus-
thus a fair and substantial
Yep.
relationship exists between the
Between
general
the zoning
public.
arts and the applicant.
So Adair, at the end of relief being sought, and before, for the foregoing reasons, insert, thus, did you say?
Yeah, thus a fair,
Thus, a fair and substantial relationship does exist between the general public purposes of the ordinance and their application to this law. And that completes the
I
thought.
think that addresses, I hope that addresses what
Yeah.
somebody was raising. Any other questions or readers? An amendment, not an amendment, a motion to approve this finding as amended?
I'll move.
So moved, was that?
I'll move.
You
Yeah,
did.
I'll move it.
Second. Any further discussion? All in favor?
Aye.
Okay. Before we go on to Alan's, I think that what we will probably do is simply follow on from the prior findings of June 10th with these as an eventual notice of decision, and eventual these additional findings. That's the format we will use. Just keep
They're all
going
being
with that.
one,
Yep.
one document.
That's the thought. So if you have some questions about that, we'll change that later. All right, let's go to Alan's draft. And did you change the language on the variance thing, number 3 language? You didn't, did you?
No,
Okay, so
I don't believe I have.
so the very first half of the page
Is a cut and paste.
Is
Yeah.
cut and paste, okay.
Yeah.
Okay. And so the next part, your factual findings.
Right. Starting at, in number 3 above.
The paragraph above facts pertinent to this request says, it's anticipated that all residents will take their meals in the common house. That's not true. Isn't the
Yeah.
idea, maybe one, dinner or, but not mandatory?
They have their own kitchen.
They have
In
their
some
own-
places, okay, all right. Well, then let's
You could
change
say-
that.
Just strike.
All right. Okay. I can live with that.
You can read this one.
I'm not gonna read the facts, no, but are there any questions or changes on the facts that they stated? This variance, by the way, for the purpose of anyone who may be just listening out there, gentlemen, is there's a footprint limitation in our zoning ordinance of 11,000 square feet. And it is our interpretation under the zoning rules that when you have connections between buildings, as has been proposed in this case, a total connection of 3 units, they exceed that by substantial amounts. Is the maximum building permit 7,000, and I think you're going to say that the between the 3 buildings is going to be a
Yeah.
total of 13,517.
Yep. Yep. And I was using the most recent submission for facts off of their
Okay.
equal something.
That Bobby submitted.
That Bobby submitted to us, yes. That's where I got the numbers from.
Okay, so let's, before we go on, from any other changes to the facts, or factual findings which will be set forth in the total finding?
I'm biased on that, so I didn't see any.
Can't remember now. Because I can't remember where I saw it, but someplace in your draft here,
Yep.
you mentioned that waivers for covered places to facilitate
Yeah.
disabilities
Right.
are permitted. I can't remember where I saw it.
Yeah,
It's
I agree.
it's
Three.
number
Number
3.
three.
Number 3,
Number 3.
go to the back, so the first,
Yeah.
first page.
Connecting covered bridges for access between structures are considered to be important. So the under sense of the limit,
It's
the
meant-
waiver to that limit to accommodate disabilities.
Right.
And that's a true statement, but that provision of the ordinance goes a little bit deeper than that.
Okay.
I think it says that when the specific disability, with the person who specifically has the disability, no longer has the use of that.
That's correct.
So it's designed to be, to address a single person with a unique situation.
It is.
And I don't know whether.
Yeah, it says,
you want to add that.
in granting any waiver to this paragraph, the ZBA may provide in a finding included in the waiver that the waiver shall survive only so long as the particular person has a continuing
Use of the
to
premises,
use
so
the
it's an
premises.
individual use.
It's an individual use.
Correct.
And
The implication, though, and that's why I don't know that I brought it with me, but in the Ryan case down on the River Road, we did not put a time limit on that or an expiration date of that. In that particular instance where that lot was, by connecting the garage with the house, exceeding the footprint. It's a very small lot, I'll grant you, but the point was that there wasn't any time limit, or statement. if I
For her
recall,
residency,
For her
basically.
residence at that point. So,
Okay.
that was
It's
where I.
probably not important then.
Yeah, that was where I started from, was that particular case.
Yeah, and it says the Board of Adjustment may provide it in a finding.
Yeah. Which was the word that jumped out at me.
It's a discretion.
Yeah.
All right, yeah.
But I guess I have to believe that we're, in terms of some of these criteria, that, that a waiver, the argument for a waiver is much stronger here than in the other
Yeah.
instances.
That
And so I
was-
guess the question is, do we really need to deny, all the requests for waivers for variances?
We don't have to.
We don't have-
We have to vote on this motion. I mean, this,
However, whether, I think that the bottom issue is that the connection increases the footprint of one structure
Sure.
because it's connected, because we've got these connecting bridges, although they don't have footprints. They do exist and they connect them so that it becomes one structure by our interpretation.
But you could make the argument that, well, I think that's an unnecessary hardship, or,
That was, I think, where I first started from with that one, but I then came to the point of view that this, because my first draft said something to that effect, but then the lawyer came back and cut it all to shreds. And admittedly, I had made a mistake, because I had thought that the removal of the bridges by granting the waiver, in my mind, negated the connections, but it doesn't. They're still connected, whether the bridges are an issue or not. In that the three have become one, and we've always considered those as a connection between each of the structures that they're attached to.
wait a minute. You're saying the three buildings that are identified as the common and
The
the other
Vale
two,
and the Crest,
they're
yeah.
connected even without the bridges?
They're connected, even though the bridges themselves have no footprint.
Okay, but the bridges exist. If
The bridges
If
exist.
the bridges don't exist.
If they don't exist, then they're not connected.
Okay.
But because of what they asked us, requested from us, was a variance to that footprint.
Okay.
Then they're intending to connect them.
Yep. Okay.
It seems to me, Dan, in response to your question, that this gets to the issue of the derivative nature of these variances, that
Yeah.
had we approved the other variances, then a waiver might well have been appropriate for the disability reasons. But because it's almost moot, because we haven't approved those variances, and without those variances, this one.
It's true,
Can't
but
happen.
are we not looking, although we refer to similar findings, are we not judging these individually? And if that's the case, then Dan's is a valid point.
Except that there's been no proof that anybody has a disability.
Absolutely. And can you put out a finding that puts it on the burden of the zoning administrator and the town that this shall only be legal if and when there is a disabled person that needs to use it?
Well, one way to, we've dealt with this issue of connecting buildings
Yeah.
to satisfy somebody with a disability.
Right.
There's the case he mentioned. There's been other cases
Yes.
in the past where you could argue that, okay, guy has a sore leg for 6 weeks, and he wants to put in and connect these two buildings.
since the variance is only for 6 weeks.
Yeah, or it's.
Who
yeah.
enforces it? I mean,
And
it's-
the other half of it is, if you look at it the other way, I think, suppose they go through the process and are allowed to build 5, 6 buildings, and the ability to increase the footprint of the 1-3 building cluster is denied because we vote to deny it for good reason. So now they build the 4 or 5 buildings, and they have no connections. And it turns out that 2 or 3 or 4 or 5 or 6 of the residents who buy the properties come in with disabilities. They come back to the board and say, we want to connect them. Can we do that? Absolutely. I mean,
Yeah.
the whole
That's
table
true.
turns because they've got,
Yes.
I think that's an
Really,
argument that
yeah.
has to be
Yeah.
looked at.
Yeah.
Yeah.
I would agree.
So how does this get resolved now? 'Cause I think
Well,
it-
what's their reasoning for requesting a variance?
programmatically, I think, is their main reason.
It's because they want people to be able to stay out of the
Easily
rain when they
access.
go from one building to another.
Right,
Right,
yeah.
and there was testimony at one point, I forget which session, but that they handicap will be using the bridge.
Well, certainly, I mean, it's gonna be open, they're not gonna discriminate, it's likely there'll be handicap or
If
people
there
that
are-
age in
if-
place.
Well, there's nothing about aging in place,
I
they
know.
abandoned that.
I understand.
So I think they have to demonstrate that.
Okay, so.
Another way to look at it.
Yeah.
3 years from now, the project is granted, they build everything. 3
Yeah.
years from now, it fails for financial reasons or something else. Somebody else buys it as a mixed cluster of condos that is open to any public ownership and purchase.
Right.
No handicapped people show up.
Yeah.
What's the basis for us having granted a variance, which is, you know, a special process?
Yep.
What's the reasoning behind it? And I don't see it, not at this point in time.
No,
So I would,
just picking up what Dan said. That was-
yeah, I don't
Good
disagree.
It's a
I'm
good-
just-
good question.
I'm convinced.
okay,
All right.
well, I'm not convinced until I argue myself silly. I look at it all 6 ways.
Yeah, and it's good you do.
Well, and we should.
Yeah.
All right, any other things on the factual statements? Let's go to the findings and the variance criteria. And what I think I see you have done is followed in the general tenor of the prior variances and adding specific references
Yes.
that are applicable to this particular
Yeah.
limitation.
Right.
Okay. So I'm gonna do the same thing. I'm gonna have a reading and a voting on each of these.
Are you gonna read the request? and the variance?
That is, I thought I had, but maybe I didn't.
No, you didn't. Oh, you did? I'm sorry.
I did.
You
Okay.
paraphrased.
In paraphrase. All right. A, the variance would not be contrary to public interest finding. The board finds as follows. The proposed scale and density of the project on the proposed site is inconsistent with the purposes and objectives of the rural district and would significantly alter the essential character of this locality in the rural district. The proposed single structure footprint, well in excess of the 7,000 square foot limit set in section 514B, is not permitted in the rural district. Since numerous other properties in the rural district share similar characteristics with this lot, other property owners could request comparable variance relief, and the cumulative effect of equivalent development would be totally inconsistent with the less intrusive uses intended in the rural district. The prior expression of the town's residents in rejecting a similar but less intrusive proposed zoning amendment is indicative of sentiment that such development is not in the public interest. The zoning ordinance as currently enacted represents the public interest in what is permitted or not, and under what circumstances or restrictions. For the foregoing reasons, the variance identified in request 3 above is contrary to the public interest. Changes. A motion to approve that finding that the variance is contrary. Second? Any further discussion? All in favor?
Aye.
5-0. The spirit of the ordinance is observed finding. The board finds as follows. The objectives of the rural district include the protection of existing pattern of rural land uses and thus less intensive uses are permitted. The project as proposed, creating a single structure footprint nearly double that allowed in the rural district, would represent a substantially larger structure than anywhere else in town with the exception of the skiway and commercial districts. This would violate the objectives underlying the purpose of the rural district. For the foregoing reasons, the variance identified in request 3 above does not observe the spirit of the zoning ordinance. Any other changes? Motion to approve the finding.
So moved.
Any discussion? All in favor?
Aye.
Substantial justice is done by. The board finds as follows. Opening up the rural district to such large structures as proposed with this project results in an injustice to the town and its residents that outweighs any benefit that would be received by the applicant. For the foregoing reasons, the variance identified in request 3 above is not required in order that substantial justice is done. Changes. Motion to approve the finding.
So moved.
Second?
Second.
Discussion? All in favor?
Aye.
The values of surrounding properties are not diminished finding. Let's see if we come up with a different version this time. The board concludes that there is insufficient evidence to reach a definitive conclusion as to this criteria. It is probable that there would be some impact on property values where the variance is to be granted. That is, some existing properties might see reduction in value, while others, particularly undeveloped land, might increase in value.
It's exactly the same as our June 10th.
Yeah, a cut and paste, I guess.
Is,
Any changes?
just a question,
Yeah.
is, it's a question, is that relevant as a finding? I mean, it's a true statement, but the jury just say that it's insufficient evidence, and then stop there. It's just, it's a question, because we didn't say that in the.
You'd like to stop at the first sentence?
Yeah, it's,
Well, we said it to the board.
we did say it before, so
The
it's.
way the RSA reads
Yeah.
is that in order to grant a variance, the board must find
Right,
that the
Values.
value of
Yes.
surrounding properties is not diminished.
right.
Or,
So,
yeah.
We're
so
just
in
saying-
theory, so in theory, if we can't find that as a fact,
Right.
which we're saying here,
Right.
we don't need to meet any of the other 5 criteria, which is sort of weird.
I understand. Okay, it's.
And
I
any
just-
one of these, I think, could defeat the.
Right. Yeah, it needs all
That's
five.
absolutely right.
But I think it's.
That's fine.
I
Leave it
think
the way it
it's,
is.
I think it's useful to be complete.
Yeah, okay.
All in favor of the finding?
Aye.
Last, E, little enforcement of the provisions of the ordinance would result in unnecessary hardship finding. The board finds as follows. The board finds that the lot is neither unique nor distinguishable from other similar properties in the rural district. Many properties along Route 10 in town have the characteristics of agricultural soil mixes, wetlands, and steep slopes, and low population densities. The ordinance has delineated such properties as part of the rural district to preserve and protect such features, and to regulate development to minimize excessive growth and maintain features consistent with the rural setting. The magnitude of the proposed use is not reasonable, particularly in light of the site conditions that characterize this and similar properties. The proximity of the lot to the property and hospitality business of Lyme Lodge does not alter the developable status of the lot. Since the owner may pursue other, albeit less intrusive residential development under the current terms of the ordinance, a fair and substantial relationship does exist between the general public purposes of the ordinance and their application to this lot. For the foregoing reasons, little enforcement of the provisions of the ordinance does not result in an unnecessary hardship, and the variances set forth in request 3 is not approved.
Should that be variance or variance?
Singular, it should be variance.
Yeah.
Yep.
Variance requested.
No, the variance, that's what,
Okay.
yeah,
Set forth in
yeah.
Any other changes? Motion to approve the finding?
I move.
Second?
Any further discussion? All in favor?
Aye.
Okay, so that deals with,
Now, just for a matter of interest, I think it's nitpicking, but should we move to deny the request for a variance from 5.14, and perhaps we should do the same for the variance requested in total? I believe we did that.
I think we did, so we will do that.
Yes, we should.
That's the first motion, and why don't you make a motion?
I move that we deny the request for a variance labeled number 2, which is a variance from ordinance section 515C, permit lot coverage of whatever, you've got the numbers.
Yep.
I move that we deny that request for a variance.
Second? Any further discussion? All in favor?
Aye.
So we're simply dealing with the entire request as opposed to the separate findings.
Yes,
For
right.
the, for your provision, variance number 3, want to make a similar motion?
I so move, yes. We deny that request for a variance.
Okay. A second?
Second.
All in favor?
Aye.
I think we ought to do 2 other things, and then hopefully that maybe we can be done.
Okay.
Originally, I earlier mentioned that that while I'd like to have a statement that while we, in fact, considered and voted on variances 2 and 3 separately, They are in fact derivative in large part from the variances 1A, B, and C, which have been denied for the reasons previously adopted.
You want that added to the bottom of the finding?
Yeah,
I move that, or you moved it.
okay.
I'll second, yeah.
Any further discussion?
No.
All in favor?
Aye.
I think lastly, there have been a number of special exceptions requested to the, as part of this application. I'd like to ask how you want to proceed. My sense is that the various special exceptions requested were germane only if the variances had been approved.
May I,
Go ahead.
I move that we table any requests for variances until such time as.
Special exceptions.
Special exceptions, what they say.
Variance.
Yeah. I move that we table those requests for special exceptions until such time as they may be in fact necessary.
Discussion, does that,
I say, go ahead, that's a discussion.
does that give them a definitive decision that therefore will be credited and they can react to, even though we have not responded to the full application's request? That's a question. Or does it leave it pending? I know it's logical, but that isn't right. I don't.
It
I don't
leaves
know.
it pending only if our decisions on the variances get overturned. To my way of looking at it.
Robert Esquire, what's your sense?
Yes.
I move to table consideration of the special exceptions until we have a reading from the town attorney as to what the ramifications of tabling the special exception request until such time as various issues are dealt with.
Shall I withdraw my motion?
Why don't you second that one?
I withdraw my motion, and whoever seconds it, and I'll second it.
What I would expect that would happen is that the zoning administrator would go back to the town council and say, here is, the board wants to know what we should do on this. The options are either to put them on hold or to deny them without prejudice to come back. And so this motion certainly would allow that, so let's, does it sense to go ahead?
Good. I'd like to ask maybe if we can go to deliberation, if he has an opinion on that. My only question is whether or not that keeps them from having a decision. Yes.
Okay, we can ask that, but the issue
I understand. Okay.
is the
Go ahead.
variances, and
I understand.
and we have denied that. I don't think it precludes them in any way.
Okay.
In the past, we've tabled
Okay, that's-
during deliberation because we didn't have enough information or clarity on specific items.
Yep.
I don't see how this is different. We have,
So
Right.
can we, any further discussion? Can we vote on the motion
To table.
to table
Yeah.
pending request from council? Any
Aye.
further discussion?
No.
All in favor?
Aye.
Aye. How about a motion to go out of deliberations?
I so move.
Second. Everybody approve?
Yep.
Do you have any questions on that, David?
No, you're looking at, asking council, is it okay to table those special exceptions until such time that
They become pertinent.
again? Or should you?
Should we have denied them
Should
or
they-
done something else with them?
or voted on them.
Or do we
Or
need
might
to?
not deny it.
Do we
I
need
think
to,
they're moot,
or-
I think they're
yeah.
moot, because they're derivative from the, but let's see what he says.
Yeah.
Do we have anything further needing to be done on the Pinnacle Project at this point?
Not to my knowledge.
What I think we would propose is that the findings that we want tonight will be put together with the prior findings, and we will issue a notice of decision that has all of those features in it. And then that can be made available. to the
Pending council.
Well, I think the pending council issue is whether or not we have to take some further action, but I think we
Oh,
ought to
okay.
let,
All right.
let them go forward. If
All
they
right,
want to
that's what I
appeal-
meant.
Yeah.
That was my question.
If they want to appeal or
Okay,
ask for.
so this doesn't
reconsideration.
hold that up. That was my only, that was my question. Okay.
Any other matters on that? Okay, if I can find an agenda somewhere.